Hello and welcome to part 3 of this Field Seymour Parks webinar. Is your company absence-minded? A practical guide to dealing with long-term sickness. So in part 3, I'm going to be looking at consultation and a fair process. What's the sort of process you need to follow, particularly if you're looking towards a possible dismissal of an employee on long-term sick leave. So let's bring up the first slide here, consultation. Now, I think the first thing to say is clearly there's going to be an overlap here with the other stages that I've spoken about in parts 1 and specifically part 2. You're not going to be investigating an employee's long-term sickness absence and obtaining medical evidence in some form of vacuum without speaking to the employee. You're going to require their input as well. So there will be overlap between the investigation and consultation stages. The point to remember about consultation and investigation really is that they are driving at the same things. So the purpose of consultation is to look at the cause of absence, speak to the employee about why is it they're off work, what's causing this absence, speak about the duration of the absence, what prognosis is there for a return to work, and to consider and talk through potential adjustments, including any reasonable adjustments that you may have a duty to make as an employer under the Equality Act 2010. So while there will naturally be discussions with the employee during the course of obtaining this evidence, it is the medical evidence, I should say, it is important that having obtained a medical report, you go to the trouble of arranging a meeting with the employee to talk through the content of any report you've obtained and the results of your other investigatory work. At these consultation meetings, there's no formal right to be accompanied because you won't at this stage be proposing any form of sanction or dismissal towards the employee. However, it may well be worth offering that employee the right to be accompanied in any event. These situations, certainly when you're just having exploratory conversations, you're talking through the issues with the employee, getting their input, trying to improve your own understanding of the situation as an employer, they ought not to be too combative, and therefore you can normally be a bit more relaxed about allowing them to be accompanied. I would say particularly if they are having trouble communicating for any reason, or if they're particularly anxious or suffering with other mental health issues, then allowing them to attend with somebody else may put them more at ease and actually allow you to have more of a productive conversation with them. In terms of the location of that meeting, I would encourage you to be as flexible as possible. It's really not necessary to drag somebody on long-term sick leave into the office for this sort of discussion. You can agree to meet close to that individual's home, potentially at their home, if the employee is comfortable with having those discussions in a home environment. Before attending a consultation meeting, it's important to do a bit of preparatory work. Think about the nature of the conversation, what it is you're going to say, and in particular, any adjustments that you want to talk to the employee about, and any specific proposals that you might be putting to them. It's also important to get the employee's input on adjustments. So during the course of that consultation meeting, potentially in advance of the consultation meeting, you can ask for the employee's suggestions as to any adjustments that they think that you can make as an employer to facilitate their return to work and quicken their recovery potentially. I would take care when proposing adjustments at a consultation meeting that they are presented in such a way that the employee is not likely to sort of immediately react negatively to them. Sometimes if you're proposing a return to work with reduced duties or a slightly different role, the employee might be inclined to see that as a demotion of some sort. It's the way in which you communicate proposed adjustments is important in terms of managing that relationship with the employee. And as always throughout this process, maintaining regular contact both before and after the consultation meetings is important. So it's not really sufficient to go through your investigatory process, just have one consultation meeting and then leave it at that. There needs to be an ongoing line of communication between the parties, albeit that it shouldn't be so intrusive on the employee that you could cause yourself problems with complaints of stress and harassment. So when you're carrying out consultation with the employee and afterwards, one of the key questions to have in your mind is a return to work foreseeable? Now, in some circumstances, it may be. An employee who's been off for a while may be improving, and they've made a recovery, and it's good news, and you can integrate them back into the workplace. If so, then really what you're looking at doing is recording details of any adjustments that you've agreed to make as an employer to facilitate that return. You can hold a return to work interview and perhaps agree a schedule for follow-up meetings with the employee to keep track of their progress. And ultimately you're managing their return to work as you would do somebody perhaps who'd been on a shorter term period of sickness absence. I think naturally if someone's been off for several months, then you're going to want to keep a closer eye on them, especially if your investigation and medical evidence demonstrates a risk of a bit of a relapse, or that their recovery might only be temporary. But otherwise it's a positive development, and you can make sure that HR team and management are on the same page and ease them back into working life as before. If, on the other hand, following consultation meetings, you think that unfortunately that there isn't a prospect of a return to work in the foreseeable future, then the key questions are: can you wait as an employer to see if that condition is going to improve? And if so, how long can you wait? Do you have an urgent need for somebody to replace that employee in the business? How long have you waited so far? Is there any sign of a return to work? Does the medical evidence that you've gathered give any clues? These are the sorts of things that you'll need to consider and likely take legal advice on, frankly, depending on the specific scenario. Factors to bear in mind: sick pay, if they exhausted their entitlement to sick pay, what are the administrative costs of keeping them on your books? How large is your business? Can you be expected to accommodate that absence? Is it easier for you to accommodate that absence because there's just one person in a very large team? And what are your resources? So these are the things that will be relevant if you think that somebody's not fit to return to work because of long-term sickness. If, as an employer, you have contributed to the employee's absence, then the reality is that you will probably be expected to wait longer to see if there's any change in their condition than if the illness or injury had nothing to do with the individual's employment. So if you've weighed all of this up, you've considered it carefully, then you may face the realisation that ultimately you're going to need to dismiss this employee on long-term sick leave because there's no possibility of them being able to return to work and do the duties that you've employed them to do. Any dismissal of somebody on long-term sick leave is going to be classified as a capability dismissal, which is one of the 5 potentially fair reasons for dismissing an employee under the Employment Rights Act 96. And the first step is you're going to need to write to the employee to warn them that they are at risk of dismissal due to ongoing ill health reasons. And on the slide here, I've provided some bullet points of what you'll need to cover in the invitation letter that you send out. So it's going to be details of the employee's absence and the impact that that absence is having on you as an employer and on your workforce. Copies of the medical evidence that you've gathered. So that's going to incorporate GP statements of fitness for work. And in addition to that, any GP medical report or occupational health report that you've obtained. Details of previous consultations. So, there should be, at least a couple of consultation meetings in most circumstances where you've got notes that you can send to the employee which summarise the discussions that you've had with them, conversations about adjustments that have been explored. The letter should set out why any adjustments proposed either by medical experts, by the employee, or which have come up as part of internal discussions are not feasible in your view at the current time to make, or wouldn't have a material beneficial impact. And the invite letter should also cover off the employee's right to be accompanied. So unlike a consultation meeting that I discussed a moment ago, where you're just meeting with the employee to talk things through, where you're inviting them to a meeting, the outcome of which could be their dismissal for ill health grounds, then you must allow them to be accompanied, if they wish, by a colleague or by a trade union representative. You don't have to allow them to be accompanied by a family member or any other third party, but again, you may wish to exercise a bit of discretion depending on the particular circumstances, especially if another individual other than a colleague or trade union rep is particularly well placed to support that employee through the formal capability meeting. So when you actually get to that capability meeting, if your invitation letter has been well drafted, and I would always encourage you to seek legal advice when putting the invitation letter together, then it's going to make your life a lot easier at the start of that capability meeting, because you can really just run through all the content on the invite letter. So summarising details of absence, impact it's having on the workforce, medical evidence that you've gathered, adjustments considered, all of these points. Having done that, it's clearly important that you give the employee the opportunity to state their case, whether they disagree with any of the content in your invite letter, if so, why, and give them an opportunity to put forward why they feel that there are other options to dismissal. It's, as always, important that you take good notes during the course of any meeting with an employee to discuss long-term sickness, and particularly this formal capability meeting. So ordinarily I would recommend you have one person who is chairing the meeting and running through the content, and then an additional person who'll be perceived as neutral by the employee, who can just focus on taking a note, because it can be quite difficult sometimes to run a meeting and take a comprehensive note at the same time. If the employee makes suggestions that haven't previously been brought up, then you should be prepared to adjourn and consider those further. You could either pop out to another meeting room for a short time to discuss, or alternatively you may need to call a halt to the meeting and reconvene it on a different day if it's something that really needs more detailed consideration and investigation. I would, in most circumstances, even if you think it's a fairly clear case, avoid confirming the outcome of a capability meeting right at the end of that meeting. I think the risk of doing that is that the employee gets the impression that the whole process has really been a bit of a sham, and you've already come to a conclusion regardless of what they were going to say. So I think in most circumstances it's advisable to indicate to the employee that you will go away, take some time to think about their representations, and then come back to them with the outcome at a later date. So the second of my 3 slides, running through the dismissal process. What are the factors to bear in mind when you're considering whether or not it's reasonable to dismiss? And indeed, these are the factors that a tribunal would be bearing in mind as well when they're analysing what you've done as an employer, should the employee subsequently bring a tribunal claim against you. So bullet points are all up on the slide, as you can see. Prospects of return to work. So, if there's no prospect of return to work, medical evidence says an employee is going to be off for months and months into the future, no chance of a return, you're going to be in a stronger position to dismiss. Likelihood of recurrence. If there's again medical evidence showing that even if an employee does return to work, there's a very high chance that there'll be a deterioration in their condition, and as such there's limited possibility of that employee being fit to perform their full duties for you on an ongoing basis. That puts you on stronger ground. The need for you as an employer to have somebody doing the work. So, how crucial is the role that the employee is doing for you? Is it vital you get somebody in? The impact on the rest of the workforce. Do you have the facilities, the resources within that employee's team to cover their absence, or not? Do you really need somebody else in? The administrative costs of keeping that individual employed, size of the business, and then availability of alternative employment. So if you've got other employment that the employee is fit enough to do, but you dismiss anyway without exploring that possibility with the employee, then that may undermine the reasonableness of any decision that you've made to dismiss them. Essentially, for a fair capability dismissal, you need to demonstrate that ill health is the genuine reason for their dismissal, so it's not a cloak for some other reason as to why you wanted to get them out of the door. You'll need to show that you followed a fair process. So you've gone through consultation, you've held a formal consultation meeting with them, given them the opportunity to present their views. Your decision is backed up by reference to medical evidence, and also that your dismissal is within the band of reasonable responses that is available to you as an employer. So a tribunal will not have the flexibility to substitute its own view of what you ought to have done with regards to dismissal, but it will have the remit to decide whether or not what you've done is within the band of reasonable responses that were open to you as an employer, bearing in mind your size and administrative resources. The third slide on the dismissal process, we're looking at the outcome letter here. So you've made your decision, If it's a decision to dismiss, then these are the things that you'll need to cover off in that dismissal letter. So again, you're going to be summarising details of the absence, the impact that has had on you as an employer, summarising the medical evidence that you've gathered, covering off any arguments or suggestions that have been put forward by the employee, or perhaps in a medical report that you've received from the employee's GP or occupational health professional. So if certain adjustments have been proposed, why it is that you're not rolling forward with those. Clearly, you'll need to explain the rationale for the dismissal, and then, as with any other exit of an employee, confirm the termination arrangements that will apply. So, return of company property, any ongoing obligations related to confidentiality, for example, issue of P45, all the normal text that you would include when somebody is leaving the business. The right to appeal, I would strongly recommend in ill health capability dismissals that you offer the right to appeal. They're generally quite high risk dismissals, and by offering that right to appeal, you give yourself the opportunity to potentially remedy some defects in your process if the employee is dissatisfied with the outcome and has got good grounds for that dissatisfaction. It also gives you a bit of forewarning that that employee might be considering employment tribunal litigation against you. Then as I say, you've got that option to revisit what you've done and look at whether there might have been any failings. Finally, I would bear in mind that if you are dismissing somebody on notice, then you will have an ongoing duty to consider reasonable adjustments and look for alternative employment during the course of that notice period. And especially if somebody's got a particularly long notice period, so perhaps 3 months, 6 months, not uncommon for management or senior staff certainly, then you're not really in a position to just wash your hands of the matter because you've sent the dismissal letter out. That employee is still your employee. They're in the notice period, and you need to keep yourself abreast of any opportunities for that employee to return to the business doing alternative work, or potentially their health situation changes. Could you look at reintegrating them within the business? So that brings us to the end of part 3, looking at consultation and the fair process that you need to follow, in particular if you're looking at a dismissal. Any comments or questions on this part, feel free to contact me. My contact details are on the slides. The final part in this webinar, part 4, we'll be dealing with some complications in dismissal scenarios, common challenges, and I'll be recapping the key practical points that I've covered in parts 1, 2 and 3 already. Just to note, this is a general piece of advice on long-term sickness absence. If you've got questions about a specific scenario that you're dealing with, then do feel free to contact me or one of my colleagues in the employment team at Field Seymour Parks, and we'll be happy to advise you.